Good morning. Good morning. This is the first real one, okay? As always, y'all bow with me. Gracious Heavenly Father, again we come saying thank you. Thank you for everything you do for us individually and corporately. Give us strength, give us guidance, let us do things that are pleasing to you. Give us wisdom, character, and compassion. Lead, guide, and direct us in all that we do, not only in our daily lives, but in the lives of our jobs as members of the House of Representatives. Let us always remember that we're here to represent the people. Lead us and guide us. In Jesus' name I pray. Amen. Well, good morning. For those that haven't been on the wall, and for those of you who own rules, you know how it works. If you're a chairman, you go first. You got about 12 seconds to tell me what your bill does, and then we will open it up for the committee to have at you and maybe try not to abuse you too much. First on the wall is the chairman, Mr. Coleman. Mr. Coleman, now, are you here about bus drivers and lunchroom folks, or what are you here about?
No, sir, but I love them and I support them, and we got to keep them healthy. That's all I have to say on that subject, Mr. Chairman. Thank you, Mr. Chairman. Members of the committee, I'm here today to ask for House Bill 91, which is listed on your sheet under Modified Open Rules, third down. What this piece of legislation does, we have in this state some tests that we were giving years ago, a graduation test, criterion reference test, and a writing test. And we were teaching integrated math and a lot of other things that we're no longer requiring for students to graduate. And we have 8,000 students in our state who have met all requirements for graduation. They have done everything they could. Many of them walk with their class. Many of them have 3.5 and better grade point averages, but they cannot get their diploma because they failed to pass one part of one of the 5 tests that are no longer required that used to be required for graduation. What this bill does, it allows these students now, passage this bill, to go back and get their diploma, where many of them can get jobs, the military, Walmart, and even the firemen and policemen. Now, you cannot get a job with the GED. You have to have a diploma. We're doing something that we should have done, helping young people that cannot get work. We have a letter here that I won't read because I'm in a hurry, but a guy has taken the test 22 times, has gotten within 1 point, and has been offered a job, but cannot. He's still at Walmart because he cannot get a job because he cannot pass that graduation test. Thank you, Mr. Chairman.
We got questions? Thank you.
Thank you.
Ms. Quick.
Thank you, Mr. Chairman and members of the committee. I'm here to ask your favorable consideration for House Bill 52, which is the second bill on your list. This bill would simply make the entry of a separate parenting plan order discretionary instead of mandatory by taking out the offending shall in the current language and modifying it with unless otherwise ordered by the judge. When this statute was modified and implemented in the 2007 legislative session, there's a second part of this statute which actually makes certain criteria discretionary to be included, and then this first portion makes the incorporation of a separate permanent parenting plan mandatory according to some Superior Court judges. It's duplicative, it's unnecessary, and it has morphed into an 8-page order that you then have to do after the fact. So in order to eliminate this unnecessary expense and complication to the process, especially for pro se litigants, would ask your favorable consideration of House Bill 52.
Mr. Ramsey.
Thank you, Representative. Is this a bill from the family law section of the bar?
Only to the extent that I'm the current vice chairman of the
I know
family
you are.
law section. They have reviewed it and have no objection. It actually is supported, Mr. Whip, by the Superior Court judges as well.
Can you, for those of us that don't practice family law, can you tell us exactly what a parenting plan is and how this kind of plays? I mean, it's on the surface, it sounds like a good thing, and we're eliminating the requirement that there be one. I know there's a good reason for it because I know you know this area of the law very well, but can you kind of talk about it in layman's terms, how this plays out?
Certainly. For example, when there are two lawyers involved in the process, what you negotiate, whether in or outside of mediation, is a settlement agreement that sometimes can approach 20 or 30 pages, and that's what is signed by the parties. A parenting plan, according to Uniform Superior Court Rule 24.10, is a separate 8-page document that then must be done after the fact, which duplicates and regurgitates in many respects what is already covered in that agreement. In addition, if the judge is conducting a hearing in a contested matter, instead of being able to simply incorporate all of the terms and the provisions that are in 1991 in a separate portion of the statute, a separate parenting plan order has to be prepared by a staff attorney or otherwise and done if the judge reads this statute this way.
So to summarize, we're eliminating an unnecessary and duplicative step to the extent that it's already addressed in the settlement agreement between the parties.
And still leaving the Superior Court judge the discretion to say you didn't cover everything and you're going to have to do a parenting plan.
Excellent. Thank you.
Mr. Leader.
Thank you very much for bringing this legislation, and I do know that the lady is well recognized as an expert in this field, so this truly is a question and not an adversarial remark. I think I'm all for your legislation, but for my sort of layman's approach, can you get this? This does not allow a judge to completely not admit a parenting plan. Right? I mean, there's still going to be a parent. We're not telling Georgians here we don't think a parenting plan is important, right, in very lay terms.
No, sir. There are findings of fact and conclusions of law that still have to be in every order. And so those basic requirements still must be met, or otherwise if it's a contested matter, it would be reversible. So that still is required. We're just taking away a form-driven process that had good intentions from being a mandatory step in the process if it's covered elsewhere in a different order. Instead of there being 3 orders, for example, there might just be 1. And that obviously is going to decrease the expense. And Mr. Leader, if I could follow up on that, when this statute was passed, I was charging about $600 for an uncontested divorce with children. Now that's $1,500, and I'm losing money on that because of all the unnecessary paperwork and steps. That parenting plan requires another meeting because you've got to get, not just for you, but for the opposite party to initial everything that's in the parenting plan. So really it's a cost-saving mechanism, especially for litigants who are already in financial difficulty in the divorce process.
Mr. Willard.
Thank you, Mr. Chairman. And thank you for this bill, too, Ms. Quick. What I'm concerned about is the way it words, saying unless otherwise ordered by the court. I read that as opening to say the court does not have to put in play a parenting plan at all. And I think your desire is that there be a plan, but it does not necessarily have to be a part of the final order as a plan. Is that right?
Well, there are actually, this is one of those instances, Chairman Willard, that it might have been helpful if you saw the next piece of the statute, because it doesn't stop here. So this particular change makes it discretionary that the judge shall incorporate a permanent parenting plan into this process, which again is a separate order under Uniform Superior Court Rule 24.10. Not that the findings that are required on further down in 1991B1, that's where it is set forth all the general terms that the Superior Court should consider in any parenting order. But even that provision already says unless otherwise ordered by the judge from the original statute. So
Thank you. And we'll follow up to be sure everybody understands the parenting plan is really outlining visitation rights, custody issues, visitation, summer-wise, holidays, all these things come into play. That's part of what you have as a parenting plan, isn't it?
Yes, sir, Chairman Willard, and none of this change does not abrogate the factors in 1993, the exhaustive list of factors that were part of this same very good piece of legislation in 2007 that a trial judge considers in determining what's in the best interest of the child.
All right, so to follow up, you're satisfied that what we put here with unless otherwise ordered by the court is not going to be interpreted by judges saying, well, I don't have to enter a plan at all.
I'll try not to speak for what a Superior Court judge might decide they can do, Mr. Chairman.
I know how they read things.
Because I've successfully argued that they already have the discretion if they wanted to, if everybody was consenting, not to require this unnecessary, duplicative, and sometimes delaying step. But I would say I hope not. How about that?
I'm not arguing, but I want to be sure that when you have children involved, that there is within an order of the court something that outlines those issues of custody, visitation, rights to summer, vacation, holidays, etc. And I want to be sure that we're not getting that out of the way by that language.
And I believe that's covered in 1991B1 and the factors for 1993 without the necessity of requiring a separate court order that repeats what's already been done in an agreement or an order.
Mr. Weldon.
Thank you, Mr. Chairman. Representative Quick.
Yes, sir.
The requirements to merely file a divorce where children are involved dictate that a parenting plan is filed unless there is an agreement between the parties that they have before the filing of the action that would include all of the required information and data related to child custody, visitation, regular visitation, holiday visitation, those kind of things. And then the judge, what you're doing here just says that they don't have to duplicate that same information that can be confusing not only to the parties but potentially to the court. And isn't that true?
That's correct, Chairman Weldon, and it does not eliminate. Simply making this step of incorporating a separate parenting plan doesn't eliminate all the things the court is required to consider in 1991B1 and 1993. It just is a separate document that is not mandatory.
But, wait a second.
Ms. Quick, would it be helpful to say unless otherwise provided by order of the court? Now, my point is that there is something then in place that has this purpose of providing for the parenting plan. To be sure, it's not really saying, well, I can just order not doing it as a way of getting around it.
Mr. Chairman, if you're concerned about that, I would accept that additional language, that different language.
If I could follow up with a question to the author. If we require that information to be duplicative and it's an agreed, where this is primarily going to come into play, isn't it true that when there's an uncontested divorce or there's already been these provisions provided to the court, this information provided to the court, correct?
Yes, sir.
Thank you. Nothing further.
Mr. Williams.
Thank you, Mr. Chairman. Let me just ask you this, the gentle lady.
Yes, sir.
I hate to jump between all these learned attorneys, but in plain old midway talk, is this just eliminating redundancy in paperwork?
In a major way, Representative Williams. Yes, sir.
That's how, some folk not going to be able to ask me these sophisticated questions. Thank you.
Mr. J. Powell.
Thank you, Mr. Chairman. Representative Quick, not to belabor the issue any longer, but the previous sentence says that a parenting plan shall be required. All this does is make it discretionary as to whether it's incorporated in the final decree.
Yes, sir.
Thank you.
Thank you. Wait, Ms. Abrams, Ms. Abrams, if you'd quit talking to Mr. Roberts for a second, would you like to jump in on this? You're the only other lawyer that hadn't said something. You have a client in front of you, so you can't. Okay. Mr. Tanner is.
Thank you, Mr. Chairman. I'll still try to stick with my 12 seconds. All this HB 62, the very bottom of the page under modified structure, last bill on your sheet, this would just waive the one-year requirement for anyone that's currently stationed in Georgia on active military duty that has a child that meets all the other requirements in the law to be able to apply for the Georgia Special Needs Scholarship. And that's all the bill would do, Mr. Chairman.
No questions. Thank you.
Thank you.
Mr. Caldwell.
Thank you, Mr. Chairman, members of the committee. Believe it or not, I have a non-controversial education bill for you. In fact, you all voted for it last year. We passed it out of the House unanimously with the exception of 2 members who didn't come back. This got caught up in Senate rules last year. It's so non-controversial, in fact, that Cherokee County School District does not oppose it. All this bill does is we require all local governments to hold public hearings before they pass a budget in this state, unless they have anything to do with education. This would take what we spend the largest amount of money on in this state and require that they hold public hearings before they pass their budgets, and also make their budget available to the public. So I would be happy to answer any questions, and I would ask for the committee's favorable consideration. And that's House Bill 65. Apologies. It's the second one under modified open rule.
Mr. Roberts.
Thank you, Mr. Chairman. Just one question, Representative Caldwell, and I'm trying to read back over it. Why did we on line 18 exempt out like college and career academies?
It's a great question. The reason is that those actually fall under local other boards. They fall under local boards or in some cases other boards who are already required to hold public hearings under what this would require. So as opposed to requiring them hold public hearings and make the budgets available twice, we're going to save the taxpayers some money.
Thank you.
Thank you, sir.
Mr. Benton.
Thank you, Mr. Chairman. House Bill 86. This bill would transfer the Division of Aging Services to the Georgia Adult and Aging Services Agency. It would move aging services out of human services, which is primarily deals with children's services, and gets it under community health, where it can better function and work toward grants, and it aligns the programs better. Appreciate y'all's favorable consideration.
Ms. Cooper.
Thank you, Mr. Chairman and members of the committee. I'd like to ask for House Bill
Wait,
47.
whoa. I got to go back to Tommy. I'm doing these questions. Mr. Ramsey.
Thank you, Mr. Chairman. Is there any cost involved?
No, it's a lateral move. There's no cost. All the people will stay the same. It'll just be under a different agency doing the same job, but hopefully be able to do it better.
Right. Thank you.
Mr. Rice.
Yeah, thank you, Mr. Chairman. They do receive a per diem. It looks like it's new law in here because it's underlined. So they are paid something for their time and effort on this. Is that right?
That would be the board. The employees of aging services are already there.
Now, Ms. Cooper.
Chairman and members of the committee, I'd like to ask for House Bill 47. It's under modified structure rule. This would allow ophthalmologists and optometrists to prescribe eye drops before they reach their 30-day period if they have gone 70% of the prescription. Elderly people have trouble putting eye drops in, especially elderly people, and they often run out of their prescription before it's time for them to quit using the eye drops. Medicare has even recognized this as a problem, and this would allow the physicians to order the eye drops. It does not mandate that the insurance companies have to pay for it. The person may have to pay for it. It just allows the patients to get the eye drops they need.
Mr. Stevens. No. Ms. Cooper, is this the bill my name's on?
Pardon?
Is this the bill my name's on second?
Yes, sir.
What changes have been made to that bill since we came with it?
None, sir.
None. Okay. Any other questions? All right. Mr. Weldon.
Chairman, with respect to House Bill 52, I'd request that this bill be held one day and we'd be allowed to propose a Rules Committee modification to clarify the language in the bill. I'm sorry.
You can do it on the floor. It's modified open if you want to. I mean, if you want it held today, I'll hold it.
We'll do it on the floor.
Okay.
Thank you.
What if I don't put it on the floor?
Well, in the event you do.
All right. We're going to set it for tomorrow. Under modified structure, HB 62. Do I hear a motion? Any opposed? All right, it's on. Under open, HB 86. Any objection? It's on. Under modified structure, HB 47. It's on, or any objection? And I'm going to give you a day to figure out your bill. That's it.